California has the most heavily regulated tenant screening environment in the entire United States, and it's not close. Between state-level statutes, the California Civil Code, the Fair Employment and Housing Act, the Investigative Consumer Reporting Agencies Act, and dozens of local ordinances in cities across the state, landlords in California face more screening restrictions than anywhere else in the country. If you're screening tenants in California, compliance requires meticulous attention to detail because the penalties for violations are severe, enforcement is aggressive, and tenant advocacy organizations actively pursue landlords who don't comply. Let's start with application fees, because California has one of the most specific fee frameworks in the nation. Under California Civil Code Section 1950.6, landlords can charge a screening fee, but the fee is capped at the landlord's actual out-of-pocket costs for obtaining the screening report, or a maximum amount that is adjusted annually based on the Consumer Price Index. As of the most recent adjustment, the cap is approximately $55 to $60, but landlords should verify the current year's maximum because it changes annually. The fee must be used solely for the purpose of screening, obtaining a credit report, criminal background check, and verifying information provided by the applicant. The landlord cannot use the fee for general administrative costs or profit. California's fee provision includes several additional requirements that go beyond most states. The landlord must provide the applicant with an itemized receipt showing the screening costs. If the landlord doesn't actually screen the applicant, for example, if the unit is rented before the application is processed, the landlord must refund the fee. If the applicant provides a screening report that was prepared within the preceding 30 days, the landlord must accept that report and cannot charge a fee for a new one, unless the landlord can demonstrate that the existing report doesn't meet the landlord's screening needs. This portable screening report provision is significant. It means that applicants who already have a recent report can avoid paying additional fees, and landlords who refuse to accept a qualifying existing report are in violation of the statute. California also requires that the landlord provide the applicant with written notice of the screening criteria before collecting the fee. This disclosure must be specific enough that the applicant can evaluate whether they're likely to qualify before paying. Vague criteria like good credit are insufficient. The landlord should identify specific standards. Criminal history screening in California is heavily restricted at both the state and local level, and the restrictions have become dramatically more stringent in recent years. At the state level, California enacted Assembly Bill 1008, the California Fair Chance Act, which restricts the use of criminal history in employment. While AB 1008 primarily applies to employment, the policy direction it represents has influenced housing screening law and enforcement. More directly, California's Fair Employment and Housing Act, Government Code Section 12955, prohibits housing discrimination, and the California Department of Civil Rights, formerly the Department of Fair Employment and Housing, has interpreted this to restrict the use of criminal history in housing decisions when it creates a disparate impact on protected classes. The department has issued guidance stating that blanket criminal history policies that fail to consider the nature of the offense, time elapsed, and relevance to the tenancy can violate state fair housing law. California expanded its record sealing and expungement provisions significantly. Under Penal Code Sections 1203.4, 1203.4a, and related statutes, individuals who successfully complete probation can petition to have their convictions dismissed. Dismissed convictions under these sections cannot be used as a basis for denying housing. California also enacted automatic record relief under AB 1076 and subsequent legislation, automatically clearing certain convictions after completion of the sentence without requiring a petition. Landlords cannot consider records that have been dismissed, sealed, or automatically cleared. California legalized recreational marijuana, and the state enacted specific protections. Under the marijuana legalization framework, landlords cannot discriminate against applicants based on legal cannabis use. Additionally, California enacted AB 1793 and subsequent legislation to facilitate resentencing and record clearing for marijuana convictions, meaning many historical marijuana records are being cleared from individuals' histories. Landlords should not use marijuana-related records for conduct that's legal under current law. Several California cities have enacted their own criminal history screening restrictions that go significantly beyond state law. San Francisco enacted the Fair Chance Ordinance for housing, one of the most restrictive in the country. Under San Francisco's ordinance, landlords cannot inquire about criminal history until after making a conditional offer of housing. The initial application cannot contain any criminal history questions. After a conditional offer, the landlord can conduct a criminal background check, but cannot consider arrests that didn't result in conviction, sealed or expunged records, juvenile records, marijuana convictions, or convictions older than 7 years for most offenses. An individualized assessment is required, and the applicant must be given an opportunity to respond before the conditional offer is withdrawn. Oakland enacted similar fair chance housing provisions. Berkeley has enacted tenant protections that affect screening. Los Angeles has been active in criminal history screening discussions, and the city's progressive political environment supports additional restrictions. Sacramento, San Diego, San Jose, and other California cities have varying levels of local regulation. Landlords operating across multiple California cities may need different screening procedures for different jurisdictions, similar to the complexity that exists for rent control. HUD's 2016 guidance on criminal history and disparate impact applies in California. The state's extraordinarily diverse population means that criminal history policies face intense scrutiny. California's enforcement agencies, both state and local, actively pursue disparate impact claims. Blanket criminal history policies are essentially indefensible in California. Source of income protection in California is comprehensive and aggressively enforced. Under Government Code Section 12955 and the California Fair Employment and Housing Act, landlords cannot discriminate against applicants based on their source of income, including housing choice vouchers, known locally as Section 8, CalWorks benefits, Social Security, disability payments, veterans benefits, and any other lawful source of income. California's source of income protection applies statewide and covers every landlord. The California Department of Civil Rights investigates complaints and has significant enforcement authority, including ordering damages, injunctive relief, civil penalties, and attorney's fees. Fair housing testing is conducted extensively throughout California, particularly in Los Angeles, the Bay Area, San Diego, and Sacramento, and organizations regularly identify and pursue landlords who discriminate against voucher holders. Landlords cannot reject applicants because they receive Section 8 vouchers. Landlords cannot advertise that they don't accept Section 8. Landlords cannot state, in listings, phone conversations, emails, text messages, showings, or any other communication, that vouchers aren't accepted. Landlords cannot set income requirements that effectively screen out voucher holders when the voucher plus the tenant's income would cover the rent. And landlords cannot impose additional screening requirements on voucher applicants that aren't applied to all applicants. California also has a unique provision. The Housing Authority conducts its own inspection of the unit before approving a voucher tenancy, and the landlord must allow the inspection. Some landlords have used the inspection requirement as a reason to avoid voucher tenants, but this is not a legitimate basis for rejection and can constitute source of income discrimination. For credit reports, California has additional requirements beyond the federal FCRA baseline. The California Investigative Consumer Reporting Agencies Act, Civil Code Sections 1786 through 1786-60, imposes state-level requirements on how consumer reports can be obtained and used. Landlords must comply with both FCRA and ICRAA, which means meeting whichever standard is more restrictive. Under ICRAA, the landlord must provide the applicant with specific disclosures when obtaining an investigative consumer report, which includes reports that go beyond a standard credit check to include personal interviews, character references, or lifestyle inquiries. The disclosure requirements are more detailed than FCRA's standard provisions. California also requires that if a landlord denies an application based on information in a consumer report, the landlord must provide an adverse action notice that complies with both FCRA and California law. The notice must identify the consumer reporting agency, inform the applicant of their right to dispute the information, and provide a copy of the report upon request. California's notification requirements are among the most detailed in the country. California's fair housing protections under the Fair Employment and Housing Act are the broadest in the nation. Protected categories include race, color, religion, national origin, sex, sexual orientation, gender identity and expression, disability, familial status, marital status, age, ancestry, genetic information, immigration status, primary language, citizenship status, military and veteran status, and source of income. The extraordinary breadth of these protections means that virtually every characteristic an applicant possesses is potentially protected. The immigration status and citizenship status protections are particularly notable. California explicitly prohibits landlords from discriminating against applicants based on their immigration or citizenship status. Landlords cannot ask about immigration status, cannot require proof of citizenship, and cannot use immigration status as a screening criterion. This protection is significant given California's large immigrant population and distinguishes the state from most others. The primary language protection means landlords cannot discriminate based on the language an applicant speaks. While landlords can conduct business in English, rejecting an applicant because they primarily speak Spanish, Mandarin, Tagalog, or another language violates California law. The California Department of Civil Rights is one of the most active fair housing enforcement agencies in the country. The department investigates complaints, conducts independent investigations, and can pursue civil penalties and damages. California also has an extremely robust private cause of action. Tenants can sue directly for fair housing violations and recover compensatory and punitive damages, plus attorney's fees. Fair housing organizations throughout California, including the Fair Housing Council of Orange County, Housing Rights Center in Los Angeles, and numerous others, actively pursue screening discrimination. From a practical standpoint, California has the largest rental market in the United States, with more renters than any other state, and the market is extraordinarily diverse across its regions. Los Angeles is the largest rental market in the country by total number of rental units. The economy is driven by entertainment, technology, healthcare, aerospace, international trade, tourism, higher education, and virtually every other industry. The applicant pool is one of the most diverse in the world, including significant populations from every continent. Screening in Los Angeles must accommodate applicants with international credit histories, income from international sources, non-traditional employment in the entertainment and gig economies, and diverse cultural backgrounds. Los Angeles's local ordinances, including the RSO Rent Stabilization Program, add requirements on top of state law. LA's screening environment is among the most complex in the nation. San Francisco has an extremely expensive and tight market with extensive local screening restrictions. The Fair Chance Ordinance for Housing makes San Francisco one of the most restrictive cities in the country for criminal history screening. Source of income protections are aggressively enforced. The applicant pool includes technology workers with high incomes, service industry workers struggling with affordability, immigrants, students, and a significant population receiving housing assistance. San Diego has a strong market driven by the military. Naval Base San Diego is the largest naval fleet concentration in the world. Biotech, tourism, and healthcare. Military tenants represent an enormous portion of the San Diego market. BAH rates for San Diego are among the highest in the country. Landlords in San Diego should have streamlined military income verification processes. San Jose and the Silicon Valley corridor have extraordinarily expensive markets driven by the technology industry. The Bay Area's screening landscape includes both state-level restrictions and various local ordinances in individual cities. Sacramento has experienced dramatic growth as California's capital and as a more affordable alternative to the Bay Area. The market has tightened significantly. Fresno, Bakersfield, Riverside, San Bernardino, and the Central Valley and Inland Empire have more affordable markets that have grown as residents have been priced out of coastal California. These markets serve increasingly diverse populations. Orange County, Santa Barbara, Monterey, and coastal communities have expensive markets with varying local requirements. One critical best practice for California landlords: determine the exact regulatory status of every property you own. Which local criminal history screening ordinance applies? Is the property subject to rent stabilization that affects the screening context? What are the specific local requirements for your city? California's layered regulatory environment means that properties in different cities may require completely different screening procedures. Maintain location-specific compliance procedures for each jurisdiction where you own property. Another critical best practice: never charge more than the current annual maximum for screening fees, and always provide an itemized receipt. Accept portable screening reports that are less than 30 days old unless you can specifically demonstrate why the existing report is insufficient. Refund the fee promptly if you don't actually screen the applicant. Fee violations are among the most straightforward screening violations to identify and prosecute, and California tenants and their advocates actively pursue them. A third critical best practice: never state in any form that you don't accept Section 8 or vouchers. California's source of income protection is the most aggressively enforced in the country. Fair housing testing is extensive and ongoing. Remove any discriminatory language from every communication channel: listings, websites, phone scripts, email templates, text messages, and in-person conversations. Train every person who interacts with applicants that source of income discrimination carries severe consequences in California. A fourth best practice: never ask about immigration or citizenship status. California explicitly protects these categories. Remove any immigration-related questions from your application form. If you require identity verification for a legitimate screening purpose, such as running a credit report, accept any valid government-issued identification and do not require specific documentation that only citizens would have. California limits the security deposit to 1 month's rent for unfurnished units and 2 months' rent for furnished units. This cap was reduced from 2 months and 3 months, respectively, under the Tenant Protection Act. The deposit must be returned within 21 days of the tenant vacating, along with an itemized statement of deductions and copies of receipts. Failure to comply can result in liability for up to twice the deposit amount in bad faith cases. The strict deposit limitations make thorough, compliant screening absolutely essential. Your financial protection is minimal, and the consequences of accepting a problem tenant in California's slow eviction process are severe. For the complete guide to California tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.